Chapter 2 Indian Contract Unit 1 Nature of Contracts Learning Outcomes. After studying this chapter, you will be able to understand the meaning of terms, agreement, and contract, and know the distinction between two. Contract essential of contracts agreement enforceability by law. Agreement offer plus acceptance. Contract essential of the contract types of contract. Legal rules regarding validity offer kinds of offer. Legal rules regarding validity offer kinds of offer. Essentials of a proposal. Communication of offer. Legal rules regarding validity acceptance. Communication of acceptance. What is what is contract? The term contract is defined under Section 2H of the Indian Contract Authority as an agreement enforceable by law. The contract consists of two essential elements: an agreement and its enforceability by law. Agreement. The term agreement given in Section 2E of the Indian Contract Authority is defined as every promise and every set of promises forming the constitution for each other. The constitution for each other. To have an inside inside the definition of agreement, we need to understand promise. Section 2b defines a promise as when the person to whom the proposal is made signifies his assent thereto. Uh, the proposal is said to be accepted. Proposal, when accepted, becomes a promise. The following points emerge from the above definition. When the person to whom the proposal is made signifies his assent on that proposal which is made to him, the proposal becomes accepted. The proposal becomes accepted. Accepted proposal becomes promise. Accepted proposal becomes a promise. Thus, we say that an agreement is the result of the proposal made by one party to other party, and that other party gives his acceptance thereto, of course, for mutual consideration. Agreement बराबर offer proposal offer plus acceptance plus consideration. Agreement बराबर offer plus acceptance plus consideration. Enforceability by law. An agreement to enforceability by law. An agreement to become a contract must give rise to a legal obligation, which means a duly enforceable by law. Thus, from above definition, it can be concluded that contract 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 बराबर agreement plus enforceability by law. Enforceability by law. On in elabo- on elaborating on ele- on elaborating the above two concepts, it is obviously that contract comprises of an agreement, which is a promise or a set of reciprocal promises. That a promise is the acceptance of a proposal giving rise to a binding contract. Further, Section 2H requires an agreement capable of being enforceable by law before it is called contract. Where pa- where party where parties have made a binding contract, they created rights and obligations between themselves. A agrees to B to sell car for 2 lakhs rupees to B. Here, A is under an obligation to give a car to B, and B has the right to receive the car on payment of 2 lakh rupees, and also B is under an obligation to pay 2 lakhs to A, and A has a right to receive 2 lakhs. Hmm. Father promises his son to pay him pocket allowance of 500 rupees every month, but he refuses to pay later. The son cannot recover the same in court of law, as this is a social agreement. Social agreement. It mm, this is not created with this is not created with an intention to create legal relationship, and hence it is it is not a contract, and hence and hence it is not a contract. So, the law of contract deals with only such obligations which has resulted from agreements. Such obligation must be contractual in nature. However, some obligations are outside in outside the purview of the law of contract. An obligation to maintain wife and children, an order of the court of law, etc. These are statutes. These are statutes. These are status. These are status obligations, and so out of the scope of the Contract Act. An obligation to maintain wife and children, an order of the court of law, etc. These are status obligations. So status obligations, and so out of the scope of the Contract Act. Difference between agreement and contract. Basis of difference agreement contract. Meaning every promise and every set of promises forming the consideration for each other. Promise plus consideration बराबर agreement. Contract agreement an agreement enforceable by law. Agreement plus enforceability बराबर contract. Scope it's a wider term including both legal and social agreement. Contract it is a it is used in a narrow sense with the specification the contract is only legally enforceable agreement. Basis of difference. Legal obligation agreement में it may not create legal obligation. It may not create legal obligation. An agreement. Sorry. It may not create legal obligation. An agreement does not always grant rights to the parties. Contract necessarily creates a legal obligation. A contract always grants certain rights to every party. In nature, all agreements are not contracts, or all contracts are agreements. Essential of a valid contract as given by Section 10 of the Indian Contract Act. The agreement, pre-consent, competency of the parties, lawful consideration, legal object, not expressly declared to be void. Two parties not given by Section 10 but are also considered essential. Two parties intention to create legal relationship, fulfillment of legal formalities, certainty of meaning, possibility of performance. In term of section 10, in term of section 10, all agreements are contracts if they are made by the free consent or the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared to be void. Since section 10 is not completed and exhaustive, so there are certain other sections which also contains requirements for an agreement to be enforceable. Thus, in order to create a valid contract, the following elements should be present. The following elements should be present. Two parties, two parties, one cannot contract with himself. A contract a contract involves at least two parties, party making one party making the offer and the other party accepting it. A contract may be made by natural persons and by other persons having legal existence, example companies, universities, etc. It is necessary to remember that identity of the parties be ascertainable. ascertainable. Hmm. To constitute to con, to constitute a contract of sale, there must be two parties, seller and buyer. The seller and buyer must be two different persons a person because a person cannot buy his own goods. In state of Gujarat, in state of Gujarat versus Ramanand Co. S and Co. When on dissolution of partnership, the assets of the firm were divided among the partners. The sales tax officer wanted to tax this transaction. It was held that it was not a sale. It was held that it was not a sale. The partners being joint owner of those assets cannot be both buyer and seller cannot be both the partners being joint owner of those assets cannot be both buyer and seller. Parties parties must intend to create legal obligations. There must be an intention on the part of the parties to create legal relationship between them. Social or domestic type of agreements are not enforceable in court of law and hence they do not result into contract. A husband agreed to pay to his wife certain amount as maintenance every month while he was abroad. Husband failed to pay the promised amount. Wife sued him for the recovery of the amount. Here, in this case, wife cannot recover as it was a social agreement and the parties did not intend to create any legal relationship. Wolford versus Wolford. Mr. Lekpal promises to pay rupees 5 lakhs to his son if the son passes the CA exam. On passing the exam, the son claims the money Here, the son could not recover as it was a social agreement. Are sold goods to be on a condition that he must pay for the amount of goods within 30 days. Here is intended to create legal relationship with B. Hence, the same is is contract on failure by B for making a payment on due date. A can sue him in the court of law. Other formalities to be complied with. In certain cases, a contract may be written or spoken. Has two legal effects. There is no difference between a written contract and a contract made by word of mouth. But in the interest of the parties, the contract must be written. In case of certain contracts, some other formalities have to be complied with to make an agreement legally enforceable. Be enforceable. For example, for uh, for for example, contract of insurance is not valid except as a written contract. Further, in case of certain contracts, registration of contracts under the laws which is in force at the time is essential is essential for it to be valid. Example in the case of immovable property. Example in the case of immovable property. Thus, immovable property. Thus, thus where there is where there is any statutory requirement that any contract is to be made in writing or in the presence of witness or any law relating to the registration of documents must be complied with. Certainty of meaning. The agreement must be certain and not vague or indefinite. A. A agrees to sell to B 100 tons of oil. There is nothing certain in order to show what kind of oil was intended for. XYZ Limited agreed to lease the land to Mr. A for indefinite years. The contract the contract is not valid as the period of lease is not mentioned. The contract is not valid as the period of lease is not mentioned. Possibility of performance. Possibility of performance of an agreement. The terms of agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. Possibility of performance an agreement. The term of agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. A agrees to B to discover treasure by magic. The agreement cannot be enforced as it is not possible to be performed. Now, according to Section 10 of the Indian Contract Act, the following are the essential elements of a valid contract. Now, according to Section 10, the Indian Contract Act, the following are the essential elements of a valid contract. Valid of a of of a of a valid contract. Offer and acceptance or an agreement. Offer and acceptance or an agreement. An agreement is the first essential element of a valid contract according to Section 2E. Section 2, Clause E of the Indian Contract 1872. Every promise and every set of promises forming the consideration for each other is an agreement. Is an is an is an is an is an is an agreement, and according to section 2b, section 2 clause b, a proposal when accepted becomes a promise. A proposal when accepted becomes a promise. An agreement is an outcome of offer and acceptance for consideration. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. This can also be understood as identity of minds in understanding. The term with the terms with consensus ad item further such further such con, further such consent must be free. Consent would be considered as free consent if it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. A. A. Whose owns two cars is selling red car to B. B thinks B thinks he is purchasing the black car. There is there is no consensus said item and hence no contract. To determine consensus ad item, the language of the contract should be clearly drafted. Thus, if A says B, will you buy my red car for 3 lakh rupees? B say yes to it. There is said to be consensus ad item, that is, the meaning is taken in same sense by both the parties. Are threatened to suit B if he does not lend him 2 lakh rupees and B agreed to it. Agreed to it. Here the agreement, here the agreement is entered entered into under coercion and hence not a valid contract. Students may note that the terms coercion, undue influence, fraud, misrepresentation, mistake are explained in Unit 3. Capacity of the parties. Capacity to contract means the legal ability of a person to enter into a valid contract. Section 11 of the Indian Contract 1872, Section 11 of the Indian Contract Act specifies that every person is that every that every person is competent to contract who is of the age of majority the according to the according according to the law to which he is subject and is of and is of sound mind and is not otherwise disqualified disqualified from contracting by any law to which he is subject.